And it's becoming a very good year for the Second Amendment. We just got a final judgment in the case Silencer Group Foundation v. ATF, and it's a good one. So the only reason why the National Firearms Act isn't a horrifically unconstitutional violation of the Second Amendment is because it's actually a tax bill, levied under the Tax Clause and the Interstate Commerce Clause of Article 1, Section 8. They effectively made suppressors and other accessories almost illegal by making them incredibly expensive. Accessories such as a stock or grip that makes it easier for disabled people to defend themselves. You know, like the one Joe Biden lied about and said it increases both caliber and muzzle velocity. Or a shotgun that's a little bit shorter so it's easier to use for home defense. Making or transferring one carried a $200 tax on top of all the regulatory requirements and approvals. Then, last year, Congress eliminated the tax. So the plaintiffs sued, saying if there's no more tax, there's no more reason for the law. And the court just agreed, quote, "The court permanently enjoins the federal government from enforcing the challenged provisions of the National Firearms Act as to untaxed firearms against the plaintiffs and, where applicable, the plaintiffs' agencies, political subdivisions, members, and customers, both current and future." Now, it's not all good. This was not a finding on Second Amendment grounds. Judge James Wesley Hendricks decided the case based on the Enumerated Powers Clause, and on that basis considered the Second Amendment claim abandoned. You might also notice that it's party-specific. A district court judge is not supposed to be setting policy for the entire country, as we've seen so many corrupt ones do as of late. But the decision is extraordinary nonetheless. At least from this one company, you can get a suppressor from the ordinary FFL background check process. Of course, there may be state laws that still apply where you are. But my prediction is that it won't be long before other dealers and manufacturers follow suit, and we can get this up to the circuits where the real decisions get made. You see, now there's a real commercial incentive for this. And they can argue that the decision applying only to the plaintiffs makes an illegal class system. They also have standing based on their own commercial injury if they have to continue the process that Silencer Shop Foundation is now exempt from. And the cowardly little judges don't have to stress themselves with a novel new theory. They'll just point to Hendricks's. Also, I had a gander at the docket. 15 states by my accounts were listed as co-plaintiffs, so their agencies count under this law too, although not their residents. But it may not be too long before other states decide they want the same protection, not only for their own agents, but for their residents as well. On the other hand, I don't want you thinking this is going to be a big race to nationwide uniformity. Right now, we're at the messy part of the process, which will only get messier if some other judges decide to go the other way. And when you get a whole bunch of judgments one way and a bunch the other, then the ATF is going to have a serious administrative nightmare. That may be the easiest way to victory, convince the ATF that it just isn't worth trying to enforce it anymore.